Good morning. I'm David Keating. I'm president of the Center for Competitive Politics, and welcome to our conference on Citizens United versus FEC after 5 years. This event is being streamed online and is being recorded for people to view it who can't make it here today. And before I get started, I first wanted to thank the Cato Institute for allowing us to use their facilities in this nice conference room and all the work that their staff did to help us put this together, including inviting people from the Cato conference lists. Of course, thank you also to our speakers who've come in. Many have come in from out of town, and thank you to our interviewers who will help the conference be interesting, I hope. The format for this conference is it's an interview, basically. We have either working or former journalists who are going to be moderating each panel, but they're not a typical moderator. They're going to ask questions, and hopefully that will make for a very interesting discussion. Our first panel is titled "The Story Behind the Lawsuit." The interviewer is David Drucker, who's senior congressional correspondent for the Washington Examiner, and he's previously reported for CQ Roll Call and the Los Angeles Daily News. And the person being interviewed is Michael Bowes. He's general counsel to Citizens United. He was instrumental in the lawsuit, of course, and he's also vice president of Citizens United and Citizens United Foundation. So without further ado, we'll let the interview begin. Thanks, David and Michael.
You're welcome. Just one operational thing. Do I press this when I...
It's on. Maybe we need to slide it closer.
All right. Thank you very much. I'll try and get out of the way and let Michael do most of the talking. And I'm not live tweeting the panel. I'm just checking my notes because I can actually read what I type better than when I chicken scratch it. Michael, the first thing I wanted to ask you is, did you know what you were getting into when you started legal action? I mean, did you have a sense of where it was going and the ramifications that the decision could have?
Well, the answer to that is both yes and no. When we brought the case, our primary goal was to be able to put our film, Hillary the Movie, on the air and to be able to run advertisements promoting the sale of the film without being subject to the campaign finance regulatory regime. We had 10-second ads that were requiring 4-second disclaimer statements. And in fact, when we filed the lawsuit, as it was initially pleaded, the focus was on the disclaimer and disclosure requirements. At that point in time, we didn't have an offer to put the film on TV. It was only a few weeks after we filed our initial case that we received an offer from a video on demand company to put the film on television. So we amended the lawsuit. But our primary goal was just to be able to put our film on TV, to let people see it, and to be able to advertise that film. But at the same time, we had always been looking for another opportunity to go after the ban on electioneering communications under McCain-Feingold. We were one of the litigants in the original McConnell case, and we had challenged, our angle on that challenge was a freedom of the press challenge that got us nowhere. So the answer is both yes and no.
Of all of the results and what has come since Citizens United in terms of how money is raised and spent and where it goes, is there anything in particular that you're most pleased with from just the 30,000-foot level of how things changed for everybody that maybe you couldn't have anticipated, but you're really glad to have seen come about?
Well, I think there's been a more than a significant, I think there's been an overwhelming change for the good in the whole mindset with respect, at least on the part of the courts, with respect to campaign finance regulation. prior to the decision, the ability to raise money and spend money on independent expenditures or even what they call electioneering communications, which is just communications which mention the names of candidates, was severely restricted. If you recall, the PAC option, you could only take in contributions of $5,000 maximum to fund those activities. It's hard to run a national advertising campaign on $5,000 contributions. And so the decision itself has certainly opened up the field to allow many people to speak who otherwise couldn't. And it's really leveled the playing field. Not in the sense that everybody has equal amount of money to spend. I don't view that as leveling the playing field. Leveling the playing field means equality of opportunity. Everybody has the same opportunity, the legal opportunity to raise the money to fund their speech. They have an opportunity to join together, to raise money to fund their speech. So it's opened up the field and created a sense of equality of opportunity to promote an organization or individual's viewpoints.
How has it changed things for Citizens United specifically? What has it meant to your organization, and how have the last 5 years, been different than how you guys operated beforehand?
Well, we always like to think of ourselves as a group that was on the map, but we're clearly now a group that's on the map. There's never a time when anybody speaks about campaign finance anymore that Citizens United doesn't come up. It's a household name. So in that sense, everybody knows who we are. And it's certainly opened opportunities. We've now just completed, I believe it was our 24th documentary film, Rocky Mountain Heist, which was a film about Colorado politics that was hosted by Michelle Malkin. That was another legal battle as well, subsequent to Citizens United, that we won an injunction from the 10th Circuit U.S. Court of Appeals to be able to air our ads for the film and the film itself free of the state's campaign finance regulations.
Expand on that, if you will. I understand that it's sort of like the next big court case for you guys, at least at present. Talk a little bit more about it and the sort of implications it might have outside of Colorado if you guys are ultimately successful.
Well, as I'm sure many of you know, that after we won the Citizens United decision, the state of Montana basically argued that the decision didn't apply in their state; it only applied to the federal government, and so there was a legal battle over Montana. But this case involves not necessarily the full application of the Citizens United decision, but it implicates the Citizens United decision in Colorado. Colorado, like the federal campaign finance regime, includes a media exemption. That establishment media entities are not subject to the campaign regulatory regime. After our victory in the Citizens United case, the Federal Election Commission ruled that Citizens United, to the extent that we're involved in filmmaking activities and the promotion of our films, is also exempt from the regulatory regime. Colorado has a similar provision in its state constitution. It's worded almost precisely the same as the federal media exemption. But when we went to the Colorado Secretary of State and asked for a declaratory order that our forthcoming film would fall within the scope of the media exemption, he said it did not. And he said, even though that exemption might make sense, he had been forbidden by the state's courts from reading the exemption such that it would apply to Citizens United in our film. And so we filed suit in federal court there challenging the state's exemption for media entities on the grounds that it discriminated against similarly situated speakers. The traditional media, meaning the print media, newspapers, periodicals such as magazines, and broadcast stations were exempt from the regulatory regime, but an established filmmaker such as Citizens United was not. We challenged that at the trial court level, and the judge pretty much laughed us out of court and said, of course you lose. We then immediately filed an appeal with the 10th Circuit U.S. Court of Appeals and requested an emergency injunction pending appeal. We drew a good panel, and they ordered the case briefed within less than 2 weeks of the time we filed it. They heard oral argument a week later. They granted us the injunction and ruled in our favor on narrow grounds. They ruled that as applied to Citizens United, this media exemption was unconstitutional, and that the remedy was to allow us to air our film. And our film, they didn't address the commercials, but the film outside the campaign finance regime. On the commercials, they said, if the Secretary of State says the commercials are exempt for traditional media, and on the record before us we don't know, then, but if they are exempt, then Citizens United would have to be treated the same way. And a few days later, the Secretary of State issued an advisory opinion letting us know that, of course, the traditional media's advertisements for their programs were exempt. So we were able to broadcast Rocky Mountain Heist last fall, which is hosted by Michelle Malkin, and that was a significant victory. But the Secretary of State has asked for a rehearing in bank in that case, and it's interesting because one of the Secretary of State's arguments is that if they're going to lose, they'd rather lose big than lose small, and that they had lost on an as-applied basis in the 10th Circuit, but if they're going to lose, they think they should grant a rehearing so that they would lose as a facial loss, that the provisions are facially unconstitutional. We don't know at this point whether or not the 10th Circuit would hear it in bank. We've asked them not to, but we don't control that.
I wanted to ask you something. As you've approached these cases legally in an attempt to open things up and obviously break down laws that restrict political speech, strictly from a legal perspective, is there one or two areas that are the toughest challenges for you to overcome, whether it's because of precedent or constitutional issues, or otherwise, that when you're dealing with this and you're trying to anticipate what the opposition's going to say, what a panel of judges might say, what you have to try and work around in order to try and get to where you want to get?
Well, one of the more difficult issues that we're dealing with currently, and we're not the only group, is attempts by certain state attorney generals to force 501c4 organizations such as Citizens United to disclose their largest donors to the Attorney General as a precondition to be able to lawfully solicit contributions within the state. We're currently suing the New York Attorney General over that issue. Others are suing the California Attorney General over that issue, including the Center for Competitive Politics. That's one of the more difficult issues, this question of disclosure of contributors. Our case is beyond the campaign finance regime. The courts have required disclosure of political contributions, but the courts have also held that nonprofits and other entities and persons are entitled to anonymous speech outside at least the sphere of express advocacy. And so So that's one of the tougher issues that we're tackling currently, and we're waiting for a decision by the U.S. District Court for the Southern District of New York right now.
Okay, and finally, they're going to give me the hook in a second, but quickly, there was an area that might be ripe for reform involving political action committees, and you and I had talked about, and I was hoping you could expand briefly on that. And also, Citizens United has another film coming out this year, and I thought you could tell us a little bit about that.
Well, our sequel to Hillary the movie will be coming out, which will focus a lot on her career as Secretary of State. On the political, and that film will be out either late summer, we believe, or late in the year. On the issue of political action committees, political action committees are subject to the same contribution limits today that they were subject to in 1976. This $5,000 contribution to candidates, $5,000 limit on contributions received. And we see that as an area where reform is needed. The Congress has recently raised the limits for party committees. It's time to raise the limits for PACs and index them to inflation, as is the case with respect to individual contributions.
Michael, thank you very much. I enjoyed it.
Thank you.